Good morning, afternoon, or evening, depending on what time you're watching this, everyone. And thank you for joining me today. My name is Heriberto Eddie Ramirez, or you can call me Eddie or Professor Ramirez. And thank you for joining me. Today we are going to be talking about navigating the legal landscape, AI, copyright, and the ethical challenges ahead. This presentation will explore the legal battles and copyright issues surrounding artificial intelligence, or AI, in all its different facets. AI has experienced and is continuing to experience rapid growth and expansion in recent years, touching nearly on every industry from healthcare to entertainment. However, with the increasing prevalence of AI, numerous legal and copyright challenges have emerged that require careful consideration and resolution. Our first topic is going to be copyright issues in AI-generated works. As AI systems become more sophisticated, they are now capable of creating original content such as art, music, and literature, but this raises an important question. Who owns the copyright of these AI-generated works? The legal landscape surrounding copyright and AI-generated content is not well defined. Traditional copyright laws were not designed to accommodate creations by non-human entities, leaving us with a gray area when it comes to AI-generated works. Let's examine a few legal cases that have brought this issue to the forefront. So the very first one is this one. In the 2016 case of Naruto versus Slater, a macaque monkey named Naruto took a selfie using a photographer's camera. The photographer, David Slater, claimed the copyright to the photograph, but PETA, on behalf of the monkey, argued that Naruto should hold the copyright since he was the one who took the picture. While this case did not directly involve AI, it raised important questions about non-human copyright ownership that are relevant to AI-generated content. Ultimately, the court ruled that animals could not hold copyrights, but the case sparked considerable debate. So then we fast forward to 2020, and we have the case of Thaler versus USPTO. Stephen Thaler, an AI researcher, submitted a patent application for a food container designed and generated by his AI system, Dabus. Thaler listed Dabus as the inventor and sought to be recognized as the owner of the invention. However, the U.S. Patent and Trademarks Office, which is the USPTO, rejected the application, stating that only humans could be inventors. This case further illustrates the legal complexities of AI-generated creations and the need for updated copyright and patent laws. As we can see, the legal battles and copyright issues surrounding AI-generated works are far from resolved. With AI becoming more prevalent in various industries, it is crucial that we continue to examine and address these challenges and future challenges to come. In this next part of the presentation, I'll discuss AI and patent law, delving deeper into the question of whether AI can be considered an inventor. Now let's move on to the topic of AI and patent law. As we've seen, AI systems are now capable of generating not just artistic works, but also practical inventions. This poses an important question, and I'm going to read this twice. Can AI be considered an inventor under patent law? Again, can AI be considered an inventor under patent law? Similar to the copyright issues we discussed earlier, patent law is not well equipped to address AI-generated inventions. Traditionally, patent law has recognized only human inventors, leaving AI-generated inventions in a legal gray area. So let's go ahead and look at some legal cases that have tackled this issue. We previously mentioned the case of Thaler versus USPTO, where Stephen Thaler sought to patent an AI-generated invention, and the U.S. Patent and Trademarks Office rejected the application, stating only humans could be inventors. Thaler pursued similar legal actions in other jurisdictions, leading to the 2021 case of Thaler versus UK IPO. In this case, and let's break that down here, the UK Intellectual Property Office also rejected Thaler's application, reinforcing the idea that current patent laws do not accommodate AI-generated inventions. These cases highlight the need for a re-evaluation of patent law to address the increasing prevalence of AI-generated inventions. However, another important aspect of AI in the law is trade secrets. Many companies rely on proprietary AI algorithms and data to maintain their competitive edge. This challenge lies in protecting these valuable trade secrets while still disclosing enough information for the AI to function effectively and for people to understand it. The competing interests of disclosure and confidentiality have led to some high-profile legal battles. For example, in the 2017 case of Waymo versus Uber, Waymo, a subsidiary of Alphabet, sued Uber for alleged theft of trade secrets related to self-driving car technology. Waymo accused a former employee who had joined Uber of stealing proprietary information and using it in Uber's self-driving car project. Although the case was eventually settled, it brought attention to the issue of protecting AI-related trade secrets. Another notable case is HiQ Labs versus LinkedIn from 2019. HiQ Labs, a data analytics company, scraped publicly available data from LinkedIn and used it to analyze employee behavior and predict job changes. LinkedIn sought to block HiQ Labs' access to its data, claiming that HiQ Labs violated the Computer Fraud and Abuse Act. However, the court ruled in favor of HiQ Labs, stating that LinkedIn could not prevent access to publicly available data. This highlights the tension between protecting proprietary data and ensuring open access to information, or, I will say this, information that is readily accessible on the web as well. As AI systems continue to advance and become more prevalent in various industries, it is crucial that we develop clear legal frameworks to address the complex issues surrounding AI and trade secrets. So, and this is kind of where I do want to take a pause and say this. In the next part of this presentation, we will explore AI's impact on privacy and data protection and the legal challenges that arise from these specific concerns. They won't include the information that has been covered to date or thus far, but it will zero in on both privacy and data protection. So let's discuss the impact of AI on privacy and how it has led to legal battles. AI-powered surveillance and facial recognition technologies have become increasingly common, raising concerns about an individual's privacy rights and the potential misuse for these technologies. Balancing privacy rights with public safety concerns is a complex issue, and there have been several legal cases that highlight this struggle. In 2018, the case of Carpenter versus the United States, the Supreme Court ruled that the government's warrantless collection of cell phone location data over an extended period of time violated the Fourth Amendment. While this case, I'll say this, did not directly involve AI, it emphasized the importance of protecting individual privacy rights in the digital age. Another set of legal battles surrounding AI and privacy involves Clearview AI, a facial recognition technology company. Clearview AI scraped billions of images from the internet to create a massive facial recognition database, leading to lawsuits in 2020 and 2021 alleging privacy violations. These lawsuits underscore the need to carefully regulate AI-powered surveillance technologies and balance privacy rights with other concerns. Additionally, as AI systems become more sophisticated and integrated into various aspects of our lives, data protection becomes an increasingly pressing concern. AI systems rely on vast amounts of data, which can make them vulnerable to data breaches. When data breaches occur, questions arise about who should be held liable for any resulting harm, if there is any. Let's examine a couple legal cases that illustrate the challenges of AI and data protection. The first one is that in 2019, the credit reporting agency Equifax reached a settlement over a massive data breach that exposed the personal information of millions of consumers. Although the breach was not directly caused by AI, the case did highlight the potential consequences of AI-related data breaches and the need for more robust security measures. Another notable case is the 2019 case of Capital One. In 2019, the Capital One breach was this. A hacker accessed personal information of over 100 million customers. The hacker exploited a vulnerability in the bank's cloud-based data storage, which was used by the bank's AI system for credit approval decisions. The case raises questions about liability for AI-related data breaches and emphasizes the importance of robust data protection measures. As AI technologies continue to advance, it is crucial that we develop legal frameworks that address data protection and privacy concerns. This will help ensure that AI systems are used responsibly and that individual rights are protected. In the next part of the presentation, we will be exploring the impact of AI on employment law, including the potential for discrimination and bias in AI systems used in hiring, promotion, and termination decisions. So let's move on. AI and employment law. AI systems are increasingly being used in hiring, promotion, and termination decisions, offering the potential for increased efficiency and possibly objectivity. However, these systems can also inadvertently perpetuate discrimination and bias, leading to large legal challenges. AI-powered tools used in recruitment and human resource processes have come under increased scrutiny for potential violations of anti-discrimination laws. For example, the Equal Employment Opportunity Commission, or EEOC, is currently investigating the use of AI-powered hiring platform HireVue. The platform, which uses algorithms to analyze video interviews, has been criticized for potentially discriminating against candidates based on race, gender, or age. The outcome of this ongoing investigation could have significant implications for the use of AI in employment decisions. Another case highlighting this issue involves Pymetrics, a company that offers AI-based recruitment tools. In 2021, Pymetrics reached settlements with several individuals who claimed that the company's AI system discriminated against them based on race and gender. These cases underscore the need for careful regulation and oversight of AI systems used in employment decisions. Alongside these concerns, AI systems' increasing autonomy raises questions about liability. Specifically, who should be held responsible when AI systems cause harm? One possible approach is to treat AI as a person or legal entity, assigning liability to the AI system itself. However, this approach is fraught with legal and ethical challenges, as it may absolve humans of any responsibility for the AI systems they create and deploy. A series of cases involving Tesla's autopilot feature highlights the complexity of this issue. Between 2016 and 2021, I would also possibly say 2022, maybe even now, right? Even 2023, there's ongoing legal legal complexities at hand. Let's leave it at that. But there have been, and this is something that we do know, there have been multiple accidents involving Tesla vehicles operating on autopilot, resulting in fatalities and injuries. In these cases, questions arose about whether Tesla, the vehicle owner, or the AI system itself should be held liable for the accidents. While there is currently no clear consensus on how to assign liability in such cases, it is evident that legal frameworks need to evolve to address the growing role of AI in society. In this next part of the presentation, we'll be discussing AI's impact on antitrust laws and the challenges it presents in terms of price fixing and collusion, as well as ethical considerations surrounding AI applications. So let's go ahead and move on and now examine the impact of AI on antitrust laws. AI systems are increasingly being used to optimize pricing strategies and monitor competitors. However, these systems can also enable price fixing and collusion, which are illegal under antitrust laws. Monitoring and regulating the use of AI in business practices can be challenging, but there have been legal cases that illustrate the potential consequences of AI-driven collusion. In 2015, the U.S. Department of Justice, the DOJ, filed a case against David Topkins, an online seller who used AI algorithms to coordinate prices with other sellers on Amazon. This case marked the first time that an antitrust action was brought against a company for using AI-driven price fixing. Another notable case is the European Union's Google shopping case in 2017. The European Commission fined Google, I'll say that, they fined Google for abusing its market dominance by manipulating search results to favor its own shopping services over competitors. Although this case did not directly involve AI-driven collusion, it highlights the potential for AI systems to be used in a way that violate antitrust laws and one of the largest companies that we know of, Google. Beyond these legal challenges, AI applications also raise important ethical considerations. As AI systems become more integrated into our daily lives, concerns about transparency, accountability, and fairness become increasingly relevant. Ethical considerations can have legal implications as well. In 2020, IBM faced controversy when it was revealed that the company's facial recognition technology was being used by law enforcement agencies for surveillance purposes. IBM faced public backlash and criticism for the potential misuse of its technology, leading to the company to announce it would no longer offer general-purpose facial recognition software. To address these ethical concerns, some governments and organizations have begun to develop regulatory frameworks that specifically address AI ethics. For example, the European Union's proposed the Artificial Intelligence Act in 2021, which aims to create a legal framework for AI systems that prioritizes transparency, accountability, and human oversight. As AI continues to advance and become more prevalent in various aspects of our lives, it is essential that we consider the ethical implications of these technologies and develop legal frameworks that promote responsible AI development and use. In this next and leading to the final part of our presentation, we'll discuss international perspectives on AI-related legal frameworks and the challenges of harmonizing global AI regulations. AI's global reach necessitates an examination of international perspectives on AI-related legal frameworks. As countries increasingly adopt AI technologies, there is a growing need for harmonizing regulations and ensuring that AI systems are developed and used responsibly across borders. Different countries have adopted varying approaches to regulating AI. For example, the European Union has taken a proactive stance proposing the Artificial Intelligence Act to create a comprehensive legal framework for AI systems. However, and meanwhile, the United States has primarily focused on sector-specific regulations, such as those pertaining to autonomous vehicles and facial recognition technologies. One of the key challenges in developing global AI regulations is reconciling differences in legal systems, cultural values, and political priorities. I'll say that last part again, and political priorities. Despite these challenges, international cooperation will be and is crucial for ensuring that AI technologies are developed and used in ways that respect human rights and promote global welfare. The need for international cooperation is further underscored by the potential for AI-powered cyber warfare and the use of AI systems for disinformation campaigns. The rapid development of AI technology has potential to disrupt geopolitical dynamics and create new threats to global security. One notable example of AI's potential for misuse in the geopolitical context is the development of deepfake technology. Deepfakes are AI-generated images, videos, or audio recordings that can convincingly mimic real people or events. This technology can then be used to spread disinformation, manipulate public opinion, or even incite riots and conflict. The international community has already begun to take steps to address these threats, right? In 2021, the United Nations held an open dialogue on AI and international security, discussing the potential risk of AI-powered cyber warfare and exploring strategies for mitigating these risks. As AI continues to advance and reshape global dynamics, it is essential for the international community to work together in developing legal frameworks and ethical guidelines that govern AI development and use. In this final part of the presentation, we'll go ahead and summarize some of the key points we've discussed so far, emphasize the importance of continued exploration and dialogue surrounding AI's legal challenges and ethical considerations. This means that we are approaching the end of the presentation. So with that being said, let's recap some of the key points we've discussed regarding the legal battles and copyright issues surrounding AI. We began by examining copyright issues in AI-generated works, exploring the ongoing debate over ownership and the need for updated copyright laws. We then delved into AI's impact on patent laws and trade secrets, discussing the challenges of protecting intellectual property while fostering innovation as much as possible. We also addressed privacy and data protection concerns, highlighting the need for robust legal frameworks to protect individual rights in the digital age. Furthermore, we discussed AI's role in employment law, focusing on potential for discrimination and bias in AI-driven hiring decisions, along with AI's impact on antitrust laws, noting the challenges of monitoring and regulating AI-driven collusion. Finally, we considered the ethical implications of AI applications and the importance of developing legal frameworks that promote transparency, accountability, and fairness. There was also a discussion on the international perspectives on AI-related legal frameworks, emphasizing the need for global cooperation in addressing AI's challenges and harnessing its potential for the betterment of society. The legal battles and copyright issues surrounding AI are complex and rapidly evolving. As AI technologies continue to advance, it is crucial for policymakers, legal professionals, and technology developers to engage in ongoing dialogue and collaboration to navigate these challenges. By addressing the legal and ethical concerns associated with AI, we can work towards ensuring that AI systems are developed and used responsibly, ultimately benefiting individuals, organizations, and societies around the world. So with all of that being said, thank you for your attention, and I hope this presentation has provided you with valuable insights into the legal battles and copyright issues surrounding AI. Please feel free to always contact me if you have any questions, but similar to the last presentation, there's one more thing that I have to share. And that very last thing I have to share is this. For those of you interested in learning more about the legal cases discussed in this presentation, please refer to this bibliography, which provides a comprehensive list of cases and their sources. And with that being said, I will go ahead and pop off the screen, but thanks again for being with me on this journey, taking this journey for yourself, and more importantly, I hope you have a great day. Bye, everyone.